Good evening, everyone. I'm Siddharth Bhatt, BCom LLB Inter CA. This will be my first video in my YouTube channel, and today we are going to talk about one of the basic laws to exist in India as of now, which you could say is the foundation of all laws, namely the Indian Contract Act. As you can see here, it is said to act as the pillar of modern commerce. Every contract we make, it is based on the, of course there are other laws that come into picture when those contracts are made, but the Indian Contract Act is always pretty much the foundation for all these, since it literally defines the contracts which we used to make, the agreements and all. Now as you can see here, this act has existed since the British era. It was enacted on September 1, 1872. As of now, it has nationwide jurisdiction. Before 2019, it was not applicable to Jammu and Kashmir because of the Article 370 and all. But now, after the repeal of that article, it's been made applicable to that also. It consists of over 266 sections, and it has been the primary legislation which has governed all types of contracts in India for pretty much the time since it's been formulated in 1872 until present day. Now, let us move on ahead and explore this wonderful act further. Now, let's focus on what was the picture, what was the scenario, so to speak, of the in India prior to the British, prior to when the British enacted this law. First of all, as we all know, India prior to the British colonization did not exist as a single political entity. It existed as various kingdoms. Now, when it comes to these various kingdoms and regions, when areas which were ruled by Hindu kings or where the Hindu population was in the majority, they had the Dharma Shastra and the customary Hindu law, which was focused on the principle of Dharma. For those of you who have read the Hindu scriptures and all, you'll be well aware what Dharma means. And in the areas which were ruled by the then declining Mughal Empire or the other Muslim sultanates, there was the Sharia law, and in the areas ruled by the Mughals, there was the Mughal traditions, which were based on the principles formulated in the Quran and the interpretation of the fatwas issued by the various mullahs. Then, as the British arrived in India, as they slowly started conquering each and every part of India, specifically the British East India Company to be precise, then they started bringing in their own laws. Whatever laws they had formulated in England, they started implementing it in the territories controlled by them. Basically the English common law applied to them, and the courts, the judicial system of England also started to be applied here in their territories, that is to say. Then there were the princely states. Even at the height of British rule, there were several princely states which were nominally independent, but which paid tribute to the British crown. Nevertheless, they had some autonomy, so they also had their local customary law and the royal decrees which the various Indian kings, princes as the British called them, would pass. Now these were autonomous and this varied kingdom by kingdom. Now this presented practical problems, several practical problems. Number one obviously being, for instance, if you were doing trade with another, now there were two fellows, they each entered into a contract. The one fellow happened to be from a British controlled territory and the other happened to be from a princely state, or let's say from territories which were still being controlled by the Mughals prior to the British subjugating them. Now with the laws being so different, which law would apply? If the contract was broken or breached, then which law, where would you take the case to? Where would you file a suit? Would you file it in the British court, or whatever legal system the Muslim rulers or other local rulers had? So again, that was a problem. Essentially, because there was so much variety of laws, it posed a heavy problem with how to put this, with dispute resolutions, since there was so much variety, so much there was no commonality, so to speak. So you didn't know where to take your case or how to even resolve it in the first place. So as the British, I would say this especially after in the aftermath of the 1857 War of Independence, when the British put down, when the British, you could say, managed to conquer nearly all of India, that was when the colonial administration decided that they needed to standardize this law, as in when it came to law relating to contracts, formulating contracts, enforcing those contracts, they needed to have one common law applicable to all of its subjects. And of course, in the British administration of India, they intended for the commercial growth. Of course, you could say in the case of the British, it was for the exploitation of India. But nevertheless, in order to better conduct their governance here, they wanted a common law. They did not want too much obstacles to emerge, and especially in the legal arena. So which is why they decided that they would take all traditions, all local Indian traditions, mix it with their own British customs, and essentially formulate it all into one single code. Where they would formulate one code, have it written down, and then enforce it throughout the British India. Now, uh, moving on. Now let's come into why India needed a contract act. Again, what happened was, especially in the aftermath of the 1857 war, when the British captured all Indian territory, they started to expand their industries. They were obviously now for you could say the raw materials, they needed to process it and all. Not just that, just to put it this way, that they were building railways, cotton mills, then there were large infrastructure projects going on, construction of roads and all. So again, there were contracts needed to be formulated in regard to transactions between the various British controlled or Indian companies also were coming into forth, and several and private individuals if they are involved, or even companies and the British government. So obviously some legals in the formulation of these contracts, they needed some certainty that these contracts, they abided by a certain common rule, and not to mention that if there were problems, it would be enforced. Then after the British captured India, their first capital, as we all know, was Calcutta. Then after in further expansion, they started building Bombay also. Today we all know it as Mumbai, but Bombay, as it was called then, had also become a major trade center. Then Bombay, Calcutta. Then as they expanded into South India, they also built Madras, which we all know as Chennai. So these were hubs of British trade. So again, when it comes to trade, contracts are an integral part of it. So again, when it comes to trade, not to mention there were banking and credit systems also. So again, there was some predictability that was needed. I mean, if there was a uniform law, you knew what to do if you ran into some problem, or just so you knew it was safe to enter into a transaction, that there was no uncertainty. Again, in the 1860s, especially 1860s means, again, this was in the aftermath of the 1857 revolt. So what had happened was that there was a British Indian Association which consisted of various prominent members of colonial society, primarily the British expatriates who had settled in India and some favored Indians. So they were pushing for a unified legal code. At the time, the courts had become overwhelmed with disputes. not to mention the variety of laws, the hodgepodge, so you could say. So they didn't really know how to go about resolving it. So again, there was a need for a uniform code that would govern all transactions. Then the British, they felt the need to, how to put it, they kind of looked down on Indian traditions. They felt that their traditions were superior to our own. So in their view that they were helping to civilize India, to modernize India, so to speak, they felt the need to bring about a common law. Their belief was, if the hodgepodge of laws that spread throughout the Indian kingdoms and states, it was all integrated into one common law, and it was, you could say, it was congruent with British legal traditions. That would be the best way to not only modernize India but to govern it better. Then, not to mention, although this, I'm not so sure about this, but according to them, the GDP growth had also happened, especially again after 1857. The GDP growth, as at least you could say in British terms, it was growing. So again, trade was expanding. Every type of legal business was expanding. So the British again felt a need for a common law code just so they could streamline their trade and the legal system. That's all. Now let's move. Now that we have covered the background, let's move on. We make now. Okay, we have not covered it. So let's go to the steps of how this act was made in the first place. Now, obviously, no law is made within a couple of months or even a year. It takes time, at least a couple of years. So it was so back then too. Now in 1866, the Law Commission had already identified this need in the light of the conditions that I have mentioned before. So the, they had known, they had pressed the need for a unified law relating to all legal contracts. So this was also supported by the British Indian Association, which I mentioned before. Then afterwards, in 1867, the Law Commission finally started to draft the basic text of what would become the Indian Contract Act. Now, obviously, it did not do this on its own. There were prominent figures in the British judicial system which were also present in this. Namely, there were judges, there were lawyers, and of course, since this law was primarily going to affect trade, so they involved merchants as well, businessmen and all. So, however, they knew the 18. Now, here's the thing. In the reason for the 1857 revolt had been that the Indian people, that is us, we had felt that they were completely disregarding the Indian traditions, which is why we had rebelled. But after putting down the rebellion, the British decided that they needed they could not exactly just transplant British law into India. The conditions were far too different. So they decided that so while drafting this law, they decided that instead of just transplanting British law into India, they would instead mix it with various Hindu and Muslim legal concepts. They would incorporate those into the law they intended to uh, construe and enforce throughout India. This drafting process took nearly 2 years. Then, afterwards, from 1870 onwards to 71, within a year, they presented it to what was then called the Indian Legislative Council. Today we know it as the Indian Parliament. But then there was detail. Then there were several fundamental concepts which I'll explain further. But those fundamental concepts, again there was a lot of detailed discussion, namely consideration, free consent, breach. Then again, in accordance with local conditions also, they taking into account the views of the businessmen and merchants who actually conduct their trade. Again, they had to modify the draft several times. Then, since this was British controlled India at the time, so in 1872 they took this draft to the British Crown in England for its assent. Yeah, I think it's the same thing in Britain also now, that whenever an act is passed, in India it usually goes after passing it in the Lok Sabha, Rajya Sabha, they go take it to the president for approval, right? In Britain, as it was in British India back then, they instead took it to the British monarch. Back then it was the king, now also it's the king only. So after the king approved it, then it became the Indian Contract Act that as we know it today. Now that we have finally explained this background, let us now move on to the core of the act. Now what the act covers, what are the sections and what do the sections will cover, that we'll see now. So introductory sections 1 and 2. Now obviously not just Indian Contract Act, any act, it will for the beginning sections will always cover the definitions of or whatever core concepts are there in that law. Then there are preliminary provisions which you could say they form the foundation for further concepts expounded in the law. Then obviously since it's about contract, this law will cover what are the contracts which are for how the contracts are formed. Now that will be offer, one acceptance, intention, consideration principles. Again we'll cover this further. Then there's capacity and consent, as in the legal capacity is how is the party able in legal terms to enter into the contract or accept it. Consent as in can the party accept the terms of a contract. Then the legality of the contract, as in can the contract be enforced in law. If there is a dispute or anything, could the contract be enforced by that by the court to whom it is taken, before whom it is put, excuse my error. Then performance obligations, like if the contract is violated, there are obligations. Can those obligations be put on the party and so on. Then again there are very special contracts and all, like there is agency, agency as in principal agent. As you know, there are agents who act on behalf of other parties to do daily business and all. Indemnity, you could say it's a form of insurance. Then guarantee, bailment and all these concepts I'll cover further. Moving on. Now, what is a contract? Let's go into that. Now, a contract, let's start with section 2 subsection A. Contract starts with an offer. Now, what is an offer? An offer means it's a clear proposal with acceptance. So what happens is, let's say I want to sell a car. Now a party comes to me to buy the car. So I offer the car to him. As in I have proposed to him that I wish to sell the car to him. Now that is a clear offer I have made. And I have also indicated, and of course that offer means obviously I cannot sell the car for free. There is a certain price I have to ask of him. So I have to specify the price as well. Then after you make an offer, the other party, like say again coming back to the car transaction, the man to whom I have offered to sell the car, he has to accept it. As in he has to agree that yes, he will buy the car from me. And that acceptance has to be unconditional. Unconditional as in there has to be no qualifications, no conditions. As in he can't like if I suppose set a price to him, like I'll sell this car for 10 lakh rupees, he has to agree to accept it for 10 lakh rupees. If he tries to bargain, like if he tries to reduce the price or something, then that does not become acceptance. That's a qualification. Now again, if I accept the qualification, then it becomes a valid acceptance. But otherwise, no. He has to agree to accept it for the price that I am telling him to. Then consideration. Now consideration is the price. Now the 10 lakh rupees that I was talking about in this example is the price, is the consideration. Now this consideration, it can be monetary, sometimes it's also barter. Like sometimes as you know, there are transactions where if you are exchanging two used items, like if you are selling a car and instead of offering you money, he offers you his laptop or something as equivalent. That also is a valid consideration, since you could say provided if you accept it. Again, acceptance here is important, but consideration need not necessarily be monetary. It can be non-monetary also, like I said with the laptop thing. Then capacity. Capacity as in, is the party legally bound, as in can the person, would the law deem the party suitable to enter into a contract? Like if I to, like for in the, this is governed by sections 11 to 16, and just to put it briefly for now, I'll expand on this further. The party must be 18 or older, minimum 18. As per the Indian Majority Act, this was again formulated during the British age. They set the limit at 18, minimum age for adults. Then he has to be of unsound mind. Sound mind. He has to be of sound mind. Sound mind as in, he has to be able to understand the contract. He has to understand just what the contract means, how it can benefit him in any manner. As for instance, basically, if you took this contract to a court, and if the court questioned the aggrieved party or whatever, and the aggrieved party somehow was unable to understand what the contract actually meant or how it affected him in any manner, then the court would deem him as of unsound mind at the time he entered into it. And he should not be disqualified either. Disqualified as in, you could say, just to give a simple example, criminals, convicted criminals usually are forbidden from entering into contracts. Any contract they usually do cannot be enforced in a court of law. So that's a simple example for now. Then free consent. Free consent as in, again, the consent has to be given of your own free will. You must not only be fully aware, you must be fully accepting of it, that you must know what you are getting into, and that you have fully agreed to enter into the whatever rewards and risks the contract proposes. That essentially you must not be either mistaken or there should be no threat from any other party to force you into it. Otherwise the contract, well, it's voidable. Voidable as in, it's not void, but it will be your choice to enforce it. You can choose not to enforce it. Again, we'll expand on this further. Then the last is lawful object. Lawful object means the purpose of the contract must be completely legal, as in something which can be enforced by law validly. It must not be for any illegal purpose. You could say in simple words, for a criminal purpose. Now, legal purpose would be selling goods like cars or property or whatever. Illegal purpose would be like, say, if I ask somebody to kill somebody else for me, or if I contract to sell illegal drugs banned by the Indian government, then obviously that's illegal. So that can't be enforced anyway. Okay, now moving further, offer. Now I have already explained this one. The proposal has to be made to accept it. The proposal on the part of party offering to do whatever. Then there has to be very definite. There has to be very clear, very specific terms, and they should be essentially, the other party must be able to comprehend those terms, comprehend whatever those terms mean, and should be able to accept, and should be in a position to accept them. There should be no further negotiation. Like I said, the acceptance has to be completely unconditional. Then then acceptance, now the other party has accepted the contract, that's good. However, the offer will not, the offer will not become an agreement unless that acceptance, or for instance, if you are making an offer, that offer has to reach the person to whom you are offering. You can't just formulate an offer in your mind and keep it there. You have to actually tell the other person that yes, I am willing to sell this article to you at this price. Please buy it from me. And acceptance also, the man to whom the offer has been reached, he must communicate that acceptance to the offerer. Without that communication, the offer is nullified. The offer might as well not exist at all. Now as I said before, the offer has to be some, acceptance must be unconditional, but this does not apply to the offer made by the offerer. You can set conditions either preceding the offer or well, not after the offer. You can set conditions before the offer. Like if you sell the article, like the car that I said before, you could set a condition like I must receive a down payment of, let's say, 5 lakh rupees. Now that is a valid condition regarding the offer. It's pretty common and it can be enforced. Then this must not, the offer, when you make the offer, it must, both the offerer and the acceptor, they must make, the offer should be such that both intend to be bound by it. That it must not just be something of an opinion, like, you know, oh, this car is, I think it's the lowest price is this, then I'll take this. I think this is the only worth for it. Or negotiations, bargaining, like I said, bargaining for lowering the prices and all. That's not being bound by the contract. You're just trying to fix the terms of the offer, but the offer has not come into being yet. For coming into being, the terms have to be fixed, completely fixed, and it has to be accepted unconditionally. Now, offer versus invitation to offer. Now, there are differences. So there are the layman terms, these are often mistaken for the same, but they are not the same. Offer means it is a definite, you could say it's a definite one which is made to a particular person, or when the other person picks up an item, looks upon it, which may belong to other person, and he offers to buy it and all, as in it is very specific, like he has offered to buy it or sell it with an intention that he would do it, that he would be that the other party would accept it, and in turn they would be bound to fulfill whatever promises they made to each other. That is a definite offer. Invitation to offer means, let's say you go to a mall, there are several hi-fi shops where they put items for sale on the shelves outside, on the display shelves. Now that is not an offer, as in the shops, wherever they put these items, they are just inviting you to buy those items. They are not exactly, it's not a definite offer. You can just choose to take a look and go. You are not entered into an offer. The offer you'll enter into only when you pick up an item, you go to the counter and you offer to buy it. That is when it becomes a definite offer. Again, there are several types of offers. One offer being general offer. General offer means you could say newspaper ads or internet ads. Like there are some product offers being made, or advertisements, or or let's say lotteries and all. So what happens is, this is an offer that is made to the public. That is, anybody who reads newspapers or watches the net, if they look upon this, they can choose to undertake whatever is being offered on the net. Anybody could do it. It is open to all, not for specific persons. That is then a general offer. Now, when does it get accepted? It gets accepted when you decide to take up on whatever offer is being put on the net or newspapers or whatever other media, and you choose to act on whatever conditions are entailed in that offer. That is when you accept it. Okay, now moving on. Now we covered offer. Now let us cover the next step, acceptance. Now, as I said before, acceptance means when you choose to accept whatever the other party is offering you, along with the terms and conditions he puts to you during the time of the offer. Now, condition number one, like I said before, this must be unqualified and unconditional. When you accept something, you have to accept it without any conditions on your part. You have to basically accept whatever the other fellow offers you, along with the terms and conditions he sets forth, not yours. If you put forth any conditions, like say if you bargain for a lower price and all, that becomes a counter offer. It does not become acceptance. The counter offer will be up to the original offerer to accept it. If he doesn't accept it, then might as well there be no offer at all in the first place. Again, this has to be communicated to the offerer. The mental assent alone is not sufficient, as in, okay fine, he offered you and you think over it and you decide to accept it, but you just, it's just mentally, like in your mind. No, you have to tell him, whether it be by voice if you are physically present, or by email, by if it is by computer, or mobile conversations and all. Silence usually, as I said, silence does not indicate acceptance generally, unless and until there are very specific, the conditions of that offer are such that if you choose to remain silent, it is presumed as acceptance, but otherwise it's mostly not. Those instances are pretty rare. Then timeliness. Now let's say if a man offers you to sell a flat, let's say, and he wants you to accept, he wants you to respond to his offer within say 6 months. Now, or not just 6 months, just about any reasonable time. The reasonable time for any such contract would be anything. It depends on market conditions or general practices. I would say in terms of flats, it's about 2 years or something, maybe a little less than that. Whatever it may be, within the time that is usually acceptable in the local business customs, you must accept that, you have to accept it or reject it or whatever. If you do not do so within that time, then the offer lapses. The other party will presume automatically, he has the right to presume that you have rejected the offer. You cannot if you take it to the court, you cannot exactly put the defense that I was thinking over it and it was too much of a big matter for me that I couldn't respond and all. No, there is a reasonable time within every business where you have to accept it. If not, rejection is an automatic presumption. Then if the offerer, if he either dies, like let's say in very special contracts which usually require the offerer himself to perform them, let's say performing arts like painting pictures or anything that requires very special skills where the offerer himself has to do it. If he dies, then the offer is terminated, it's done for. Or if he goes insane, like if he's unable to do it any longer because of being unable to mentally comprehend what he's asked to do or what he was asking to do, then that also terminates. Then there are two types of acceptance. One is express acceptance, like I said, whether it be through vocal acceptance, like if you are physically present using your voice, or emails or WhatsApp messages, SMS, or or even through phone calls. Or if it is a written contract, if you put your signature on it, that is also express acceptance. Implied acceptance would be, let's say it just means that you have already accepted. Like if you sell the car and he makes the down in the condition there was the down payment of 5 lakhs, and you make the payment of 5 lakhs, that automatically means you accept it. There is no need to say yes or no need to give specific indications. The payment of the money itself is acceptance. Now, there are rules for acceptance. One rule is that when it comes to post, nowadays nobody bothers with post. Everybody usually just does electronic acceptance, WhatsApp, SMS, email for mobile phone calls and all. But back in the old days, when it was just postal, uh, by acceptance by post was effective when it was posted. Like on your side, if you chose to post your acceptance and it was out of your power, then the acceptance became effective. Again, when it comes to offer and revoking that offer, for that it requires receipt on the other side. The person to whom you are making that offer or the person against whom you are revoking that offer, they need to receive that offer or revocation. Usually the electronic stuff we do nowadays, email, phone calls, SMS, WhatsApp and all, they usually follow the receipt rule. When it comes to the postal rule, again the postal rule doesn't apply much today, but just for your information, the acceptance is effective on communication to offerer. As in, if you communicate your acceptance to offerer, the man who is offering to sell or buy from you whatever, on when you accept whatever offer he is making and you communicate it to him, and if he receives it, then the acceptance is valid. Or when it comes to postal rule, then when you post it to him. Now moving, consideration. This is something that is very important. Without consideration, there usually is no contract. Nobody would make a contract in the first place unless they want something in return. So what are the core elements of consideration? Now the section 2D defines consideration as something of value given. Obviously, if you offer to sell a car or anything of value, and the consideration would automatically be the monetary consideration, that is the price, the monetary value of whatever I was saying, 10 lakhs earlier, or any non-monetary one also, like an equivalent, an item of equivalent value, like say a laptop or something else. Then the essence is the consideration usually follows quid pro quo, that is mutual favors. That is, I sell the car, you pay me whatever I want from you in return for this. That's quid pro quo. Now principle is consideration must move from the promisee to the promiser. As in, the if I have promised to sell the car to you, then the consideration of 10 lakhs for equivalent article, as an article of equivalent value, it must move from him to me. That's how consideration moves. Now, timing. Present and there are three types of consideration: past, present and future consideration. Now present consideration, that is if you agree to pay someone such amount now, that is valid for obvious reasons. I don't need to expound that further. Then future consideration, like say usually cars or any other major articles of very high value, obviously you cannot make payment for them all at once. Usually you make an instant down payment of a particular amount, then you pay it in installments. The installments are future consideration. That also is valid. Past consideration is usually generally invalid. There were, I think in English law, in the original English law, there were provisions where past consideration also was regarded as valid. But so far in the Indian contract law, past consideration, that is consideration for any acts done in the past, is usually regarded as invalid. Now, again, like I said, there are many types of consideration. One, the characteristics of this consideration is it has to be real, that a consideration must actually exist. It must not be something fictitious, something like something you promise, like hidden treasures or anything which you don't exist at all. That's not consideration. Or it has to be very valuable. Like it could, like for instance, 10 lakh rupees in money is valuable, but a laptop is also valuable, right? So that also. Again, when it comes to consideration, uh, value doesn't necessarily have to be sufficient. Like even if you buy a, now here it is written 1 pound, but let's, for Indian terms, let's take like 10 rupees or 100 rupees or anything. Like if you just choose to give 100 rupees for a watch, like you buy a watch which costs a 1,000 rupees, but you just pay 100 rupees, then even if it is taken to court, the court will deem the contract valid. It will not deem the contract invalid just because you paid inadequate consideration. Regardless, a small warning here, the court can dig deeper into the contract, make inquiries as to whether there was anything involved in the contract which could make it voidable, as in, like I was saying earlier, free consent, whether the contract truly had free consent if the consideration was so inadequate, that the court could investigate into. So I would say it is advisable to pay adequate consideration anyway. Illusory promises are invalid. Like I said, the discovery of treasure by man, like a promise to pay some magic treasury or anything which doesn't exist at all. Now you can see valid examples: payment of money, transfer of property, property as in laptop or whatever other movable item you have. Then performing service, like this usually goes for employment contracts. Like if you are hired by a company, they agree to pay you salary. In return, you have to work for them on a daily basis on the usual address. That's performance of service. Forbearance, like you agree not to do something in return for consideration. I think this usually applies to insurance contracts. Like if you are, like if not insurance contracts, usually indemnity contracts. Like this one party promises to pay you this if you agree not to do this, or if you agree not to harm him or anything. Then promise to act later, like if you offered I don't know any examples of this, so we'll just skip this part. Invalid examples, considerations which are invalid: vague promises, like we already expounded on the offer part. Vague promises are usually promises which are like very vague, like you agree to pay him. If you buy a watch from someone, you agree to pay him between the range of 500 to 1,000. Now obviously that's somewhat definite but not quite exact. It's vague because you don't know what's the exact price you have to pay. You've been given a range. A range is not exact, so again that's a vague promise. Then performance of existing legal duty, like an easy example is if you pay a bribe to someone in a government office to do something which he's bound to do anyways, obviously that bribe is an invalid consideration. You could even be prosecuted for it. Then pure moral obligation, like this is a bit vague. Pure moral obligation, that usually depends on case to case. I can't exactly expound what is an pure moral obligation. It usually goes into the morals that govern our society, like what is presumed by society to be correct. Again, that differs. It differs with the changing times and customs, so I cannot really say any further on this. Then love and affection in commercial context. Again, there are exceptions to this also. Again, it's not expoundable further. We'll see. We'll have to see about this later. Then exceptions. There are exceptions to valid and invalid. Some considerations could be valid. Like I was saying about love and affection commercial context, it is usually invalid. I mean, gifts between family members and all, usually there is presumed to be no consideration. But for instance, if you agree to give a flat, if you make a deed where you gift someone a flat, uh, and how to put this, and he accepts it, as in it's a gift deed. Like you made a agreement to gift someone a flat to a close relative without him giving you anything in return. So a gift deed is valid. It can be enforced in a court of law if there is any dispute. Then promissory estoppel, like this happens where let's say you pretend to be a legal officer and you agree to perform services like say and regulate the formulation of a contract or whatever between two parties. Later on it turns out it wasn't you didn't actually have the authority to do so, but because you presumed it that and because the contract went further due to the both parties presuming your authority, so you cannot exactly get out of it. That's promissory estoppel. Quasi contracts, you could say these are contracts, not fully contracts in the sense of the law, but some coming close to it somewhat. Anyway, moving on. Now, who can make valid contracts? Capacity to contract. Now, who can make this? Again, this is governed by sections 11 to 13 of the Act. So, there are several the parameters which govern the validity, which govern who can enter into legally enforceable contracts. Now, what are these parameters? Parameter number one, age. As per the Indian Majority Act, the minimum age fixed for a person to attain majority, it's 18 for all parties involved. That is, prior to the age of 18, you are not allowed to enter into anything. As in, whatever you do, your guardian is presumed to be responsible for whatever whatever stuff you do, and if that stuff is taken to court, the enforceability rests on your guardian. The capacity to make contracts which should be enforceable on you yourself, that would come after you attain the age of 18 and later on, of course. Now, parameter number one. So now again, like I said, okay, before I enter into parameter number 2, as per the parameter number 1 regarding age, now minus there are exceptions. Guardians like their parents, or if they don't have parents, whoever may be their closest relatives or guardians and all, they could enter into contracts on their behalf. And if the contracts went to court, the guardians would be liable to enforce it, liable to not enforce it, liable to fulfill the terms of the contract. Parameter number 2 is sound mind. Now, what is sound mind? Sound mind, like I said before, is the ability to comprehend the terms of the contract that are right in front of you, to comprehend just how is it beneficial to you. Now, how it can benefit you in any manner whatsoever, and how does it affect the other party as well. Essentially putting, how's the contract in your own interest. Now, putting it this way, if you enter into a contract but for some reason you are unable to comprehend at the time why you should enter into a contract, or how does it benefit you in a way, or how does it affect you and the other party, then that means you are not of sound mind, and so you're not it is not like you cannot exactly have the contract enforced should the case go to court and there is a ruling in your favor, or if it is against you, you are not liable to enforce it. Again, there are parameters here, like say if a man is in an asylum for a couple of years, if he is of sound, if he's of unsound mind pretty much most of the time, so it's a moot point, but occasionally he could be of sound mind. Now that depends. If he's of sound mind, if he enters into a contract, it could be enforced, but again that's subjective. It depends on if the court takes into account. I would advise not to enter into contracts with lunatics in asylums because they usually are of unsound mind. Or if a man is of sound mind, but he is occasion of unsound mind, when he is of unsound mind, he cannot enter into a contract at that time. Let's say if it's an old person who has a problem of dementia from time to time. When he is perfectly sane, when he is not in dementia state, he could enter into a contract, it would be valid. when he is in dementia, obviously cannot enter into a contract. Again, that's also subjective. When a court takes into account such a contract, the court would obviously ask for proof of the periods of dementia he enters into. They would take opinions of doctors treating him and so on. Now, the next parameter is he should not be disqualified by law in any way. Like for instance, if India is at war with Pakistan, which is usually pretty much most of the time, we had fought what 4 to 5 wars now. So, but just to give an example, if India is at war with Pakistan in the present time, Pakistan is regarded as an alien enemy. Alien enemies, when they enter into contracts here in India, that contract is not enforceable in any manner whatsoever. Alien enemies, needless to say, are disqualified. Or you could say convicted criminals. Convicted criminals, since they are regarded as legally dead by law, especially if they are under life imprisonment and all, as long as they are serving their sentences, they cannot enter into contracts enforceable in any capacity. Okay, now moving further. Free consent. Free consent means the contract must be entered of your own free will. It must be on your own basis. As in, you must be willing to enter into the contract. You must be willing to accept whatever terms and conditions the offerers put to you, and you must be aware of the fact that, and you must be willing to accept it wholeheartedly, knowing that you are bound to fulfill whatever terms the offerers put to you before he agrees to do anything for you. Again, there are elements that vitiate as in it adversely affects this free consent. There are 4 types, there are 5 exactly. One is coercion as in by force, needless to say. If someone makes a threat, like for instance, if someone puts a gun to my head and forces me to hand him over the money, essentially putting it this way, robberies in alleyways and all, that would constitute the best example of coercion. Obviously, you would hand over the money to him, but if the robber was caught and you took to court, it would be up to you. You could choose not to and for go against the robber, as in you could choose to simply accept that the money would be in his hands, or you could ask for the money to be returned and he is liable to return it to you. He cannot keep it with you. When it comes to coercion, that's how it is. Other examples also is the same. Essentially, if you do something for whoever is threatening you or whoever is having any sort of adverse influence on you, the law gives you the choice to enforce the contract. If you don't want to enforce it, you have the right to have whatever consideration you are forced to hand over back to you. Now next is undue influence. Undue influence as in sometimes it happens that you are in some sort of relationship. Like let's say you are a hospital patient who has been in care for a long time. There's a particular doctor who takes care of you. Now obviously because he's taking care of your daily needs and medical health and all, he essentially has power over you. So if he enters into a contract with you to hand over your property to him, and should the case go to court, if on at the choice of the uh, patient or patient's family members and all, the court could decide that the doctor return the property to him on the basis of undue influence. Undue influence being the doctor had power over the patient to influence his will in an undesirable manner. Then fraud. Fraud means you could say, for let's say all these spam calls we get on mobile and all, where they make fake offers for if you pay this amount, we'll hand over this reward to you and all. You could say spam offers that you receive on mobiles. That's usually the most common case of fraud. Those parties, they are aware that whatever offers they are making are false, and they intentionally try to mislead you to take advantage of you. Again, if the fraud case comes to light, you have the power to ask for that money back. Misrepresentation. Again, misrepresentation is somewhat similar to fraud, only being the party who is misrepresenting or uh, enunciating a statement as true which is false. He doesn't know it to be false. He genuinely presumes it to be true, but for some reason he has not been able to ascertain it, or he believes it to be correct mistakenly. Now again, this is you could say there's again like the other three instances, this is enforceable at your choice. If you don't want the contract, you have the right to ask for whatever you gave it to him back, or if you can just choose to let it go and keep the contract as it is, keep it enforced and all. Then mistake. Again, there are mistake as in there is it's a mistake of fact, whether it be unilateral, that is on the part of one person, or on part of both. Let's say I have a pet dog and I agree to sell my pet dog to another fellow. Now we didn't know this, but prior to the date of sale, the dog had died of a mysterious disease. Now obviously I cannot sell the carcass to him. So since the dog is dead and neither of us were really aware of that, it's a mistake of fact. So the contract is void. You could, or it's voidable. You could still, the other guy, he could still out of compassion or whatever, for some strange reason, not that it would happen, but if it does happen, he could choose to buy the carcass anyway. Now, but however, this is fact. Mistake of law is not applicable here. Like let's say you agreed to enter into some contract, like say you agreed to provide a check to him, check to someone, and that check was uh, now it is a common knowledge that a check is usually the period for honoring that check, the validity period of that check is 3 months. Now after 3 months of receiving that check, you go and deposit it, and the case goes to court. Obviously that your defense cannot be that you were not aware that the period was 3 months. That's not allowed as a defense, because the law says explicitly that, specifically the Negotiable Instruments Act says that the validity period of any check from the time it is issued to the time of from the time the other fellow receives the check from the issuer is 3 months. So that's a mistake of law, Indian law. You are not allowed to use that as a defense. The court will never accept such a defense. However, again, when it comes to law, foreign law is okay. Obviously, even lawyers for that matter, we do not presume to know for foreign law. So obviously, if there is a mistake of foreign law, like if there was a case going on, let's say in America, and the case came to India. So if there was a mistake made during the proceedings as to how American law would apply in a particular instance in the case, then the Indian judges would be willing to forgive that mistake, because obviously nobody would presume to know foreign law, not even Indian lawyers. Now, what are the legal consequences and remedies of this free consent? Or this one, like I think I already covered the legal consequences in my prior explanation. So again, but just to elucidate briefly, coercion and undue influence, this contract is again, you can choose the party who is threatened. He can choose to either keep the contract as it is, or he can choose to enforce it. He can choose to not enforce it. I'm sorry, my mistake, he can choose not to enforce it. He can ask for the money back, and damages would be, and you could press for damages like mental damages. Essentially, if your instance, if you were shot, then you could claim damages for whatever injury you sustained due to the bullet injuries. Then you could claim damages for whatever trauma you suffered because of the ongoing threat and all. When it comes to fraud, again, it's not fraud is pretty serious. Not only are you entitled to your whatever benefit you gave back to be given back to you, you could also criminally have the defrauding party confiscated. Sorry, defrauding party prosecuted. You could take him to court, and frauds usually attract very serious jail sentences, like at the least a couple of years. Then innocent misrepresentation. Again, there are damages here which the other party can see, but because it was innocent, as in the party making the misrepresentation had no idea, and he couldn't have found out anyway that whatever he was saying was not correct, so the damages would be somewhat limited. It would be, you could say, the case would be taken to some civil court and some damages could be claimed for him. There would be no criminal liability because he did not commit a very serious offense. As for mistake of law, it is usually void ab initio. Like I said in the earlier example, if the dog is dead, obviously you would not sell a carcass. So the contract is void from the very beginning you made it. The contract might as well not have existed at all. Then a mistake on side of one party is generally not account. Like for instance, let's say you were if the guy agrees to sell the dog, and he was fully aware that the dog was alive prior to that, and he tells but the other party somehow finds out that the dog is dead, or and the other party had already been aware of the fact, but he deliberately chooses not to enforce it. Obviously the other party, if he still wants to buy the carcass, like if he thinks carcasses could still offer some money for him, like if he goes to sell it and all, or if he wants to use the carcass for any purpose whatsoever, and the other party had been aware of the death of the dog, and the buying party had been not, he could still go to the court and get it enforced, since it was a mistake on the part of the buying party, not on the part of the other one. Or maybe this example is not so suitable. I'll leave it up to you guys. Moving on. The lawful object requirement. Again, like I said earlier, the contract has to be such that it is enforceable by law, as in the object for which you are making the contract, the object for which you are making any agreement, it has to be such that if it goes to court, the court has to be able to enforce it. This contract, essentially, it must not be contracts forbidden by law, injurious to public, or against public. You could say, as in a sense, contracts to monopoly contracts, like contracts in violation of the Competition Act, wherein you conduct unlawful mergers in order to control a market and stiff out competition. The Competition Act does not allow for that. It encourages competition so that consumers could have access to quality products. Or just to give a more simpler example, hitman contracts, like you contract with a hitman to take out someone whom you do not like or whom you see in your way. Obviously, contracts to murder someone are definitely not legal. No, nobody would enforce it. You would probably end up in prison anyway. Then wagering contracts. Again, pure bets. Like for instance, if you make a bet, like if it rains tomorrow, I'll pay you this much some money. Obviously, you can't. Weather conditions are not exactly enforceable. I mean, nobody can enforce it. It's an act of God, and acts of God are unpredictable by nature. So that sort of contracts not enforceable. Again, restraint of trade as per section 27 is usually void. However, there is an exception to this. If you sell your business or the goodwill of your business to someone, and that someone makes you puts a condition on you saying that you cannot conduct the business within the premise, within the area where your earlier business was located for the reasonable period of time, that restraint of trade contract is perfectly valid. Apart from that, though, any other contract restraining trade is not valid at all. Like I said earlier about monopolies, like oligopolies, where you conduct unlawful tactics to seize complete control of a market and to drive out competition. That's under the Competition Act. that is not valid. You could be sent, basically the competition commission could enforce orders against you to take back whatever unlawful deals you had entered into to ensure complete control. Again, agreements contrary to public policy, like I said, hitman contracts or contracts for fraud, or giving and taking of bribes, are undermining justice. Undermining justice would be, let's say you pay, if there is a case going on and you're aware of a certain witness who's going to give evidence against you, you pay that witness to not appear in court. Obviously that's undermining justice. You are influencing a witness in such a way to ensure the judgment is unfairly in your favor. That you are essentially undermining the law. That is invalid. That could literally attract a criminal penalty on you if you do that. Then agreements forbidden by law. If there are if the statute itself forbids you to do something and you do it, that is invalid from the get-go, as in invalid from the very start. That contract might not exist as well. Now, when it comes to obviously when it comes to cases are highly subjective in nature. The courts will not decide on contracts just like that. They do interpret the laws, but they usually do it in accordance with the circumstances of, or the condition in which whatever contract or whatever the case which they are hearing took place. So again, they would conduct a public policy test. They would take into account circumstances. They could take into account the accepted societal values and find out if whatever that contract was made, is it perfectly acceptable by society or by the public interest and so on. So again, like I said, that this changes from case to case, condition to conditions, time to time. After all, even laws are changeable. You hear of so many amendments happening in law. So again, it's changeable. It's not fixed in time, so to speak. Now, again, there are various types of contracts. Contract number one, express and implied contracts. Express contract would be, let's say you orally say something. Again, I would say written contracts. The companies often make you sign standard contracts, employment contracts, or if you are entering into sale contracts, standard forms for sale contracts. You put a sign and accept it. That's express contract. Implied would be like if I tell you, if you respond, if you if I agree to sell you a computer for 5 lakh rupees and you pay me 2 lakhs, then I'll presume you accepted. You pay him 2 lakhs, which means you accepted it. Unilateral and bilateral contracts, that's the next type. Now, unilateral would be, obviously you promise, you could say employment contracts would come under this. Like if when you take up a job with a company, the company promises to pay you a salary of this much amount per month. Now, how do you accept it? Simple, by coming to work every day and doing whatever work they require you to do. That's how you accept it. Then bilateral contracts. Bilateral contracts is exchange of mutual promises. Like I said, it is the usual contract. I sell the car and you agree to pay me rupees 10 lakhs. Those are mutual promises. One party promised to sell the car, the other party promised to pay in return 10 lakhs. That's mutual promises. Now, executed and executory contracts. Executed contracts, you could say, are contracts that have already happened. Like the car has already been sold and the amount of 10 lakhs has already been paid to the seller. That is essentially an executed contract because both the promises have already been done, completely, fully executed. That's how it is. Then executory contracts. Executory contracts, as in performance are outstanding, means you have promised to do something, like you have promised to, let's say, sell a laptop and the other party has promised to pay you 5 lakhs for it. Now it has not happened yet, it's pending. The sale is pending, the payment is pending. That is an executory contract. Again, the remedies vary by stage, as in it differs. If one party has already performed is like if the seller has already sold the laptop, if the other party doesn't pay within a reasonable time, he can seek a remedy for enforcing the payment or uh, anything, or paying damages and all. So, same goes for the other party. The other party paid the amount, but the seller has not given the laptop. He can enforce the performance. He can enforce the sale. Conditional and unconditional contracts. Conditional contracts would be, let's say, it depends on a condition preceding to the performance. Like let's say you agree to sell the car, and but on condition that you receive a down payment of 5 lakhs first. Now that is a condition precedent, as in prior to selling the car, you need to pay him the prepayment amount first. Unconditional would be there is no such condition. You sell the car, he pays you. You sell the car on conditions prior to that. On you set out the conditions. There are no specific conditions. You just sell the car, and he promises to pay you 10 lakhs immediately. Obviously, that's not possible. Maybe installments. That is unconditional. Now, what are quasi contracts? Quasi contracts are, they are legal obligations, like just a minute. Yes, legal obligations which are enforceable by law, as these are not exactly contracts but somewhat close to it. Like let's say a public officer, he's bound, like say if you go to a government office, like say you go to a government bank for check depositing your money, the officer behind the counter is bound to take your money and bound to deposit it, something like that. It's not exactly a contract, but it's his legal duty to do so. He has to do it. If he doesn't do it, you can go to the court and have him and ask the court to enforce the acceptance of such deposit amount or whatever. Moving on, performance of contracts, right and obligations. As in, when you perform a contract, yeah, there are certain rights every party has. At the same time, there are obligations also. Now, both the parties to the contract, they have to perform whatever obligations. In sale contract, purchasers and seller have to do it. If the contract specifies a date where you have to perform it, like let's say 31st December, then you have to do it by 31st December. Or if not 31st December, if there's no date specified, if the customs of the trade say, if it is a very high value item within say 3 months, as in not specified 3 months, but it is the accepted business practice that the sale of the item and the payment for that item take place within 3 months in the usual course of business, then it must be done within that time. And as the contract specifies it, mind you, like say if the contract specifies physical delivery of the goods, then you have to physically deliver the goods. You can't exactly ask him to come over and take it, because that's not what the contract specified. If you do that, then the other party has the right to simply reject the contract. Time and place. Again, so certain contracts specify the time and place. Like say, if I sell certain kilos of rice to a, let's say if I am a producer and I agree to sell certain kilos of rice to a wholesaler, and I specify and in the contract it usually specifies the go down where I have to deposit the rice at let's say 3 p.m. Then I'm obliged to do it at that go down at 3 p.m. If the contract specifies that. I cannot do it at my own will at any other time. Otherwise, the other party, he might as well reject my performance. However, if it is usual practice, and sometimes contracts don't really specify it, mostly they don't, Then you have to take into account the wholesalers usual hours of business, and where is the reasonable place. Like the reasonable place, obviously that amount outright it would be deposited in his godown. Now if he deposits it in a godown, obviously that's the reasonable time, and that's the place he would presume for you to deposit that rice. And the reasonable time would be any time within his usual hours of business. Beyond the time if you go after the time he closed it, obviously that's not a valid performance. He's liable to not accept it. He's not liable to accept it. He might as well just say just come tomorrow, and even if you take it to court, he has the full right to say no sir, I did not, there was no valid acceptance on my part because I was not there in the first place. I was not at my business place. Then tender of performance, again like I said, the offer has to be completely unconditional, and it has to be at the proper time and place. This is for physical presence. So nowadays in the electronic age, by mobile phone calls or emails or WhatsApp messages also, they could qualify as unconditional offers. Now again, like he said here, if you have offered, if you have validly tendered the offer, if you ask to do something for the other party and if he's refused, and if it goes to court, and if the other party somehow decides to go to court, you are allowed to say in your defense that you did tender the offer at the proper time and place, you fully followed the law, then it would count as performance on your part. Then the court would ask the other party to make compensation to you. That depends on the case. Then third party performance. Now, now consideration, this part relates to consideration. Now, if consideration is paid, consideration need not necessarily come from one party. As in, let's say, if the promise to pay for a car, it did not necessarily come from the buyer. It is possible the buyer could ask someone else to pay for him if he doesn't have the finances, and then he would promise to pay the other party who paid the equivalent sum of money at the proper time when it is available. Again, that's third party performance, because the other party who paid, he did not exactly contract to buy the car. He essentially paid on behalf of the buyer. That third party performance is perfectly legal, perfectly acceptable. In fact, it comes under a special contract called guarantee, which we will cover later. Now, impossibility, like I said, if some property, let's say if you agree to sell a flat and the flat ends up destroyed in a fire, or if you agree to sell a pet animal and that pet animal is dead, or if a contract was illegal at the time when you did it, like say certain drugs happen to be legal, but later on the government designated them as harmful for use and thus made them illegal. So subsequent to that illegality, those contracts are not enforceable. So even if you agree not to do it, if you decide not to do it, the other party cannot ask to be compensated, because those contracts were themselves impossible, void. They were void from the very beginning, so to speak. Again, if there is an unforeseen event, like I said, unforeseen event would be, to quote my earlier example, destruction of property by fire. Obviously, nobody can foresee a fire. If fire destroys it, there is no obligation to perform that contract, since obviously destroyed property is not sellable in any way. Again, hardship. Let us say if you contract with the government, for instance, to construct a road, but the construction of that road is increasingly rendered difficult because of rain or any weather conditions, that does not mean you should not construct the, and the government, if it brings a case to the court, the court has the perfect right to tell you that you were not excused from not building the road. You had to build it no matter what. That said, if the road was built and if you had to incur increased costs, you could in some cases claim for compensation from the government for those costs. That's for sure. But you had to build the road no matter what. Reciprocal promises. There are promises which are interdependent. Now, interdependent promises, they usually require each party to offer own performance. What happens is, if there are two parties, let's say if a party is planning to construct a building, and obviously for that building he needs construction materials, so obviously he requires the supplier of the materials to supply those materials first, and only then the other party could construct the building, something like that. It is interdependent. Without the availability of construction materials, the building cannot be made. Those are independent promises. Or just to quote a better example, let's say if I agree to build a chair and I ask the other party to furnish me the wood I require for the chair. Obviously, I cannot construct that chair unless the other party gives me the wood. So obviously it's reciprocal. I promise to build a chair and he promises me to supply the wood. So it is mutual. It's codependent, so to speak. Moving ahead. Breach of contract. Now, when are obligations not met? So what's the definition of a breach? A breach, to quote it very simply, is failure by one party to perform obligations. That includes non-performance, defective performance. Put it this way, if one party, if I suppose I agree to sell a car and the other party agrees to pay, but I sell the car but the other guy doesn't pay, which means he has not performed his promise, which means the contract has been broken in a way. It has been defaulted on. That's a breach. Now, acceptance or rejection of breach. It is possible that whoever is innocent, if any party is innocent, he may accept that breach and discharge the contract, or he may reject. Usually the breaches are rejected only, but like I said, in the case of not free consent, the other party, if he doesn't want to have if he doesn't have the time and energy, or if he doesn't want to take the trouble of re-entering into another contract, he can just accept the contract without the breach. Then the contract is perfectly enforceable. He cannot bring up the defense later that this contract was too inconvenient for me. Or he can choose to reject it and he can ask for compensation from the defaulting party or enforce it via the court. Then there are several types of breaches also. One is actual breach. Actual breach as in the performance was not performed. In my earlier example, the refusal to pay for the car is an actual breach because he's actually refused to pay for it. It's actually happened. Anticipatory would be, let's say if he agrees to pay for it, but for some reason you got wind of the fact that he is going to be insolvent or bankrupt or anything, then you know that he won't be capable of paying for the car. You could say it's an anticipatory breach. Now what are the remedies? One consequence is voidable contract. In the cases of the not free consent part that I talked about, the defaulting party is at breach. The man who entered into a contract, he is at liberty to not accept. He is at liberty to not accept the contract. Usually it happens that he doesn't accept it, or if he doesn't want the expense and trouble of a new contract, he can choose not to he can choose to just go along with it. Then the contract is perfectly valid. The other would be damages. Even if he accepts the contract, he can ask for damages, like liquidate, like for instance, if damages for any physical suffering or any mental suffering or whatever he has undergone, usually in terms of monetary cost, he can ask for the equivalent of that from the other party through the court, or specific performance and injunction. If you don't want either of these, but if you the contract is of such an importance that you want it enforced, then you can ask the court to compel the other party to specifically perform this contract for you. That as in the court, he will once you request the court for this, the court will pass an injunction order compelling the defaulting party to perform the promise within a specified time. Otherwise, he would be liable for damages and all. This usually is done if both the parties agree that damages would be too much, or something like that. Essentially, if damages are too much. Move on. Remedies for breach. Now there are there are two types of remedies: monetary remedies, equitable and injunctive remedies. Monetary remedies as in remedies in terms of money, that you could ask for money from the defaulting party. There are many types of damages under monetary damages. One is ordinary damages. Let's say if you agree, if you sell the car and you do not receive payment, you are liable to ask for compensation of full amount of 10x, because that was natural. You asked for the price and the price was not paid to you. That's the exact amount you could ask. Then special damages. Special damages would be if there are very special circumstances, like let's say if you lost property due to some irresponsible act committed by another party, let's say arson or whatever, you could not only ask for the damages equivalent to the value of property, you could ask for some special damages because it was a criminal act. And under criminal act, and to deter the other party from further committing such criminal acts, you could ask for some extraordinary, so some very high amount, higher than the usual amount, so to say. Then remoteness doctrine. There is a case called Harley versus Baxendale, which was very popular in the British days only. It was there. Just give me a moment. Now, Hartley versus Baxendale, there was a rule. Basically, this was a very old case, an English contract law case. So now, what does this rule? The rule that was decided by the case says that if for instance, if there is a breach of contract, then the other party is liable to. Sometimes the parties may not be liable to pay the other party if there was nothing they could do about the breach. However, if the other party had special knowledge, like he knew of something that that would have inevitably resulted in the default of the contract, that the innocent party had no idea of, then he is liable to pay even more damages for that, because he had the special knowledge and he chose to conceal it. This usually applies to insider trading in companies, where companies they usually purchase, where insiders of a company usually purchase shares knowing fully well the in and outs of the stock market, or how the prices will go, and that's how they influence the stock market in the process, which means they have knowledge of the adverse circumstances which the other public shareholders don't. So in this case they could be liable for remote damages as well. Then liquidated mitigation duty. The innocent party, he has the right to ask for the damages, but it is also his duty to try to minimize the damage as much as possible. As in, he must not, how to put it, He must not he must not he must try to have the contract performed as much as possible. He must not try to ask too much from the defendant, especially if it is not within his capacity to pay that much. He must try to get the contract fulfilled by any other legal means if it is necessary. Then liquidated damages. This usually happens in case of infrastructure projects where usually there is an estimate provided to the government regarding the cost to be incurred in a contract. Now, if the government for some reason decides to cancel the contract, or if the company does not manage to do it in time, they can ask for damages equivalent to that estimate they had made. Penalty clause. Penalty clause is they usually put it in a contract. Penalty clause. However, it depends. The even penalty clause is unenforceable if it is extortionate. Extortionate as in if it asks for way too much beyond the capacity of the defaulting party. Then there is equitable and injunctive relief. There are three. There is specific performance. Court, or like I said earlier, court, if damages are not adequate, if the court deems that the monetary damages are not adequate to satisfy the aggrieved party, he can order the defaulting party to perform it. Then usually there are conditions set forth for this. One is if there are damages inadequate and the contract is certain, like if the contract can very certainly perform. Sometimes if the party dies, then his legal representatives are liable to perform it. So that's how it is. Then the party is ready to perform. Like if the party is genuinely willing to repent for his breach and is willing to compensate the other party, then yes. And if the court, more importantly, is able to supervise the contract, if it is within the court's jurisdiction and the court is able to ensure its performance, then yes, that this sort of relief is possible. Usually personal service contracts are not are excluded. Like for instance, if a man promises to paint a picture and if he dies, that depends on his personal skill. That's not enforceable. Then there are negative. Then there is injunction also. Like it is in restraint injunction case. In the case of injunction, the court usually puts an order on the other party to either do or not to do something. This is to prevent, or at least if the breach has already happened, to try to contain the damage. Then application. This relief usually applies to negative obligation. Like if you sold the goodwill of your business to another party, the non-complete clause that I was talking about, that is an example of equitable and injunctive relief. Or confidentiality clause, like when you are sharing sensitive data between two companies and all, there's a confidentiality clause saying it should not be disclosed to third parties. That is also liable to equitable injunctive relief if that happens. Now there's a practical limit to it. This is not an automatic right. This is usually at the discretion of the court. This is subjective. If the court decides that it is possible to enforce such a relief, then they can enforce it. Otherwise, no. Next. Now this is a landmark case. Let's review certain cases regarding this. One of the most important landmark cases was Carlyle versus Carbolic Smokeball. So apparently this company named Carbolic Smokeball, they had put an advertisement in a newspaper saying that if anybody was willing to try their carbolic smokeball, which was used, which would contract influenza, and of course the company will provide the cure later. So if anybody was willing to contract influenza by the carbolic smokeball they had provided, please come forward and test it. We'll pay you the money, which was about £100. Now one fellow named Carlyle, he apparently was foolish enough to try this smoke ball and contract influenza. I mean, who contracts a disease willingly, right? But he did so anyway. So here obviously when he tried to claim the reward, the company said the advertisement was just nonsense and they weren't going to pay to him money for such a stupid thing. Now obviously he was aggrieved. He contracted a disease. It's not like he was going to let this slide. So he took the case to court. So what the court held, now as we have seen with public offer, this was essentially an instance of public offer. They had put in an advertisement, they had invited the general public to, how to put this, in insert, they had invited the general public to try on their smoke ball. Obviously it was a valid offer and it was validly accepted by Carlyle when he tried on that smoke ball. Since a general offer is valid in contract law, so poor Carlyle was liable to be compensated that £100. Hope he got it. Anyway, moving on. Now there are Supreme Court, there is an Indian Supreme Court landmark also, Shenley Products versus Cario Chemicals. Now apparently there had been, what were the parties and forum, there had been some supply correspondence dispute over contract timing and consideration. I don't know what the, apparently there had been some dispute over what was the timing of the contract and what was the consideration, something. Then central issue had been what had been the timing of the offer, as in whether the parties had managed to conclude a contract or were they still negotiating. So what was the court rule in this one? The court rule was the communication was essential. Apparently, I think if based on what is seen here, the parties had just mentally assented, as in they had just put the assent in their own minds. They had not actually communicated the clear intention. So that obviously rendered the contract sufficiently invalid. That rendered the contract somewhat invalid. For to validate it, they had to communicate to each other what their intentions. So what was the principle established here? One was offer acceptance. The basic principle being, if you are making an offer and the other party accepts it, it has to be clear communication. You can't just keep it in your minds or make vague promises and all. So, but what are the commercial implications here? So, apparently from what it looks to me in this case, the documents had been pretty unclear. It happens sometimes. Sometimes you get so used to drafting, so the parties, they usually don't have the legal skill to draft clear contracts, so they draft vague conditions. Sometimes it's deliberate to leave a certain sort of vagueness so that essentially to leave contracts open-ended. That way the other party will be left clueless as to exactly how to go about it. So subsequent conditions would be so what this combustion implications were, if this contract goes to court and if evidence is to be put forth, even if the documents were not clear, if the evidence is given as to what was the subsequent conduct of the parties after that contract was made, that would be sufficient evidence for whether that contract would be enforced or not and in what manner. Now this is pretty much relevant to the modern scene, especially in the world where we usually communicate by email or WhatsApp messages or phone calls, where obviously we can't really see each other, so we don't know for sure. So this case is pretty relevant to that, as in cause you could say there are in the modern world, WhatsApp messages are especially useful as evidence. You could show those WhatsApp messages to court and the court would take them into account and decide exactly what was going on during the contract process and how exactly the contract could be enforced, if it was still enforceable, that is. Now Harley versus Baxendale, like I said, this was a case. So what happened here, there was a mill owner, some British mill owner, he shipped a broken kraken shaft, whatever that is. Then carrier apparently the man who was supposed to deliver this Kraken shaft, he delayed delivery by a week. So what happened was the miller who was supposed to receive that Kraken shaft, which apparently was vital for his production, he couldn't produce anything, so he lost profits and he sued for that lost profits. Now, what is the core principle of this? Core principle says that the damages are only recoverable for losses foreseeable, as in if the contract is not performed and if you are able to foresee what losses could occur to you, not just any loss that has somehow occurred, but that which you are able to foresee, then you could sue for those losses in a way. Then there is a two-part test. That two-part test being, one was natural foreseeable losses, as in losses for which you would automatically get the money, are ordinary damages, normal damages. Special damages, as in if the breaching party was aware of certain circumstances but did not deign fit to communicate it to you for whatever reason it may be, then the aggrieved party is liable to ask for even more money from that party. That is special damages. Communication requirement. Now, if you want to make special damages recoverable, these ordinary damages are recoverable in any way. But if the special damages are needed to be recovered, then you must communicate it to whoever is you are asking to read. Like the mill owner, he needed to communicate as to why it was so urgent that he received that Kraken shaft, that he could possibly face losses if he did not get that Kraken shaft in time. That said, he apparently didn't communicate to it. He communicated because for some reason he didn't receive those special damages. It looks that way. So you needed to communicate it specifically. Now, example being, here apparently because of him not receiving that, there was a major 10,000 pounds contract. 10,000 pounds was a very big amount in those days. So yeah, pretty big amount. So even though it was lost, it was not necessarily foreseeable. Now sure, the Kraken shaft meant the miller couldn't conduct his operations. But we don't know that for sure, that the contract, that 10,000 pound contract, nobody could foresee that contract occurring in any way. It's not every day you get major contracts. So which is why the miller apparently was could not exactly receive a compensation for that, because it was not extremely likely in any way. So this case established the section 73 of special of the Act, which says that damages must be a direct consequence, not exactly any special circumstance, but a direct consequence of whatever the other party couldn't do. And from the breaching party's position, basically the party who's done the default, from his position, he must be able to foresee exactly what had happened. Now, what is the Indian case law? There was this case law called Rajendra Prasad versus Union of India. Apparently, the first president of India himself had applied a case regarding to this, where he had applied the foreseeability test. Then commercial disputes. Obviously, special circumstances obviously means that it doesn't happen usually in contracts. So the court puts the burden on the claimant to prove that those circumstances actually existed. Only then you could claim compensation for it. So what are the steps if you do want to claim those special circumstances? One is you have to communicate to the other party as to why you want it so badly. What are the actual extraordinary circumstances which would happen? Then if there is any loss that would occur because of the non-performance, tell the other party this amount I will lose if you do not do this for me. And that includes liquidated damages in case of infrastructure contracts. And of course, on your side, you should try to minimize losses by trying to get the contract performed in alternate ways. Next, In Indian law, what is misrepresentation and fraud? I am pretty sure I covered this earlier. Fraud means intentional misrepresentation. That is, you know something is false, but you are telling it anyway to extract unlawful benefit from the other party. Now, what is the proof of fraud? When it comes to criminal liability, you must prove beyond reasonable doubt. Now, what is beyond reasonable doubt? As in, you must be able to prove in a court of law hard evidence. Like you must bring forth cold hard evidence substantiating that fraud. Without vague evidence will not be accepted in that case. Or if it is just a civil case in civil court, then balance of probabilities. Like you could say, if in a civil court, if you take it, you could balance the probabilities. Like this, if a fraud happened, then this is what would have happened, or this other part would have happened. You must balance it and see which one was more probable. Now, what are the remedies? The other part, first remedy being contract is the aggrieved party can choose not to enforce the contract. He can seek compensatory and punitive damages, that is criminal damages. Then you could even get him prosecuted for fraud under section 415 of the Indian Penal Code. As for misrepresentation, it is same as fraud, like I said, but just the party doing so is not aware of the fact that what he's stating is false. So again, this is mostly a civil case, so it's just balance of probabilities. As for nowadays, it's mostly being damages are what being awarded for misrepresentation, as in you could say um, it's essentially a court weighs the damage caused due to such misrepresentation and awards the monetary equivalent. That's it. There is no criminal prosecution here. Next. Now, when does performance become impossible? There are two performances. One is there is a doctrine of frustration and there is breach. For a frustration would be if there is a unforeseen event happens. Like I said earlier, if you contract to sell a flat but the flat caught fire. Now obviously that's an unforeseen event. No one can foresee a fire unless for some reason some other, let's say if there was some fraud in it. But anyway, let's not go deep into that. Let's just presume that fire is not foreseeable. So so obviously that's where the contract becomes frustrated, as in it is not possible to perform it at all. Then there is no liability for breach. So you could say the contract is void ab initio, needless to say. This doctrine was recognized in a case called Satyabrata De versus Som Prakash. I guess it happened sometime in independent India only. Now, there is another thing called breach. Breach, like I said earlier, if both parties promise to do something for each other and but one party doesn't do as promised, then that's a breach. Now obviously there's liability that arises against that defrauding party, against that defaulting party, and you could seek monetary damages as well. Now the risk is for now obviously the remedies would focus on compensation or specific performance, like you want to enforce the performance of that contract if the court decides it can do so. Now apparently there is a trend in the pandemic for COVID. Now because of the COVID-19 era, there were many cases. People were sitting at home in COVID, so plenty of places where contracts just couldn't be performed at all. So obviously the doctrine of frustration is being applied. People are saying, oh, this place was quarantined because there was a COVID pandemic in that area, too many COVID patients, so the area had been quarantined and all. So obviously the doctrine of frustration is being applied a lot there. However, the courts are proving reluctant to find it. They need proof that it really was frustration means permanent impossibility. Obviously, if there is a area quarantined because of COVID, the people in there would get cured. or they would get vaccinated, the unaffected ones. So that means the situation was just temporary. So obviously frustration would not apply. Frustration as far as courts are concerned means permanent impossibility. Basically, like in my example, the fire damage renders it permanently impossible. That's what the courts want, not temporary immobilization. Well, moving on. Now there are quasi contracts. Like I said, these contracts are not exactly full-fledged contracts, but they are legal obligations which are enforceable in courts of law if they are not performed for any reason. So essentially, what are these contracts? Like I said, usually government contracts, like government officers may, if you go to a court, if a government officer is there and he's bound to do something, but he doesn't do it, like he asks for a bribe or something, then that is a breach of a legal obligation. It was not exactly a contract, but it was close to that. He was bound to do it. So obviously, the court has, under the Prevention of Corruption Act, that our Indian legislature has formulated remedies to ensure that it doesn't happen. That basically the aggrieved parties, they get relief for this. Now, what are quasi versus true contracts? True contracts, they are usually created by mutual consent of parties. Both parties are aware of what they are getting into and both agree to it. Now, what is quasi contract? Like I said in earlier, quasi contracts may, the government officer sitting at the desk, if you go to him, he's not exactly agreed to do anything for you, but he's bound to do that for you. The law tells him to do it. So that's a law. So that's essentially a quasi contract, needless to say. Now, what are contracts without now what are the instances under this? One is money paid by mistake. Now obviously, if for some reason you ended up paying, like say, let's say you go by auto rickshaw to some place, and he charges you like 150 rupees or something for long distance, and you accidentally end up paying him way above that. He is bound to return the change, the excess amount. That is not an exact contract, but it is legally implied that he is bound to return the excess. If not, you are liable to have him sued to repay the excess if you take the trouble to do so. Then goods delivered by mistake. If for instance you if the goods were supposed to be delivered at a particular address, but for some reason you got the wrong address and you put it there, the man at whose address it was put by mistake, he's bound to return the goods. Again, there is no contract, but it's not necessary. Then restitution. Then under section 69, restitution means if for instance, if I undertake a contract for another person, like say if I'm working at an internship for some employer and I incur traveling expenses on his behalf while traveling for work, the employer is bound to reimburse to me the traveling expenses. It's not usually in the contract, but it's a given. It's a legal obligation. Then under section 68 there is payment for necessaries. Like if there is a minor fellow person below 18, or if a person of unsound mind like a lunatic or something is there, and if there is one person, he undertakes upon himself the obligation to supply necessities like food or other basic necessities to either the minor or the unsound person. Since they cannot exactly make payment for him, so he is bound to be compensated from the estate or property of such persons. Again, it's not a contract, but it's more of a legal obligation. Now in business, let's say there are various the contract that has been applied in business in various ways. Like say there are e-commerce contracts, like online. Obviously here there are no paper contracts. It's just you go on Flipkart or Amazon, you choose a product, you go through the daily process, you put pay now, and then by a click of the button, after some payment stuff, you accept it. That contract, usually on those sites they generate an invoice. that invoice itself is a proof of contract, needless to say. Again, this contract, this electronic contracts or and all, there are other acts, not just contract act, like Information Technology Act 2000 is now applicable to it. In 2023, 2 years back, there was another act that was imposed in addition to IT Act, which was Digital Data Protection Privacy Act 2023, I think. That act was meant to complement the IT Act. In my later videos, I might inform you all about that act. Then under Contract Act, there is now in certain forms, instead of putting physical signatures, you put digital signatures. And there are digital records you keep of those contracts or whatever transactions you've done. The court say under the law, those cases have been taken to court, disputes relating to all this. The courts have held that digital signatures are valid and the digital records are also valid. They can be submitted as evidence and the proof, and it can be enforceable. Like if you put a digital signature, the contract on which that signature was put is enforceable against any party. Then cloud SLAs, uptime, data protection, intangible consideration. I think intangible consideration would be relating to Bitcoin or something. I have no idea. But I suppose Bitcoin was recently prohibited, but but the government has allowed it to be put. Some limit has been put. Then data protection clauses. Like I said, there is this GDPR and Indian compliance. There is essentially in modern contracts where you, especially in contracts relating to intellectual property, where companies often exchange intellectual property amongst themselves, like secret of making new foodstuffs or new manufacturing techniques and all. They are liable to maintain. There's a data protection measure saying that this data shall not be leaked to any other party outside those two parties. So that is perfectly applicable. Then there is a Supreme Court trend when it comes to electronic communications. Obviously, because the parties are not present, so we do not know about the mannerisms. So over there, the court has decided to objectively interpret WhatsApp messages, like basically to look at those messages objectively, pilfer out the nonsense and just get to the core of what those contract related messages mean. Now, as everybody knows, AI is being increasingly used by everyone, whether it comes to making contracts or just about everything. AI is now pretty much one of the most important aspects. Now what happened, now the courts have held that AI is not exactly a legal individual. For AI does not have legal capacity. So even if you use AI to make a contract, you have to send that contract to the other party. You have to agree, that party has to accept that contract. Basically, you have to discuss that contract amongst yourself, make some modifications and bring it to its final form. Essentially, even if you use AI to make the contract, the AI is nothing but a tool. There has to be a human element involved in a contract. The court will not just accept an AI contract just like that. Now, pandemic effects. As everybody knows, the COVID-19 pandemic led to a temporary large-scale immobilization throughout India. So people were locked up in their homes, they couldn't go to work and all. So, and those of you who done work from home, they would know that you couldn't just go outside. So remote work, work from home, so to say. Force majeure as in it's Latin for act of God. Now obviously diseases are acts of God. There are conspiracy theories about how COVID came about, but let's not regard that. Let's presume this to be an act of God. Then there are frustration limits. Now, like I said earlier, many people went to court claiming that COVID-19 made an area impossible. made an area impossible to access, made working in that area impossible due to it being quarantined and all. So the contract was permanently impossible to be made. Obviously, not permanently impossible, but they put the doctrine of frustration, saying that the contract could not be performed at all. Obviously, the courts did not accept it, saying that COVID diseases pass. Yes, people get seriously affected, but they do get cured, or even if they end up dying, there are legal representatives who could enforce that contract. So it's not permanently impossible, it's just a temporary immobilization. So frustration would not apply. So practical implication. Nowadays, every contract is made online, whether it be via email or WhatsApp chatting and all. So the courts have concluded that binding contracts could be made entirely online if the proper procedure is followed, if all the provisions of the act are followed, free consent, unconditional acceptance. If all of that is done, then even online contracts, pure online contracts, they are acceptable. Moving ahead. Now, obviously, no law is completely fixed in time. If a law is completely that way, then the law would have to be repealed and a completely new law put in place, which is troublesome in its own way. So even though the Indian Contract Act is a British colonial era law made all the way back in 1872, this one has seen plenty of amendments. Not to mention other acts made to complement this act. As I said before at the introduction, Indian Contract Act is essentially a foundational law. Based on that foundation, there are other acts made. One was Sale of Goods Act 1930, which specifically governs the sale of movable property. It introduced implied conditions and warranties instead. Like if you purchase a electronic product, it usually comes with a warranty saying that if any damage happens to the product, it's liable for free repair over that period, over a certain period, like say 2 to 5 years or something. Then there was a Partnership Act that came into in 1932, which codified contracts between two or more persons when they constitute a firm to run the business together. Then there was Arbitration and Conciliation Act, one of the more recent laws made in 96, which presides over alternate dispute resolution methods apart from litigation courts. Litigation in courts is tremendously expensive and time consuming. So most people usually prefer arbitration over an arbitrator, presided over by an arbitrator, that would, you know, enable faster dispute resolution, lesser cost. Or mediation and conciliation, which are again by mutual consent and which again aim for speedier, less money consuming dispute resolution. Well, moving on. Then yes, 2000, in the year 2000, there was an Information Technology IT Act, like I said. So how did this act exactly influence it, you may ask? Now, in the olden days, before computers and related technology were there, physical signatures were a thing. Now, even if contracts used to be printed on paper. Now, what has this act done? It has enabled electronic contracts. You could make contracts entirely on the computer. You could, and instead of putting physical signatures, you could put your pen drive in and put your digital signatures. So even that contract has now been held to be perfectly validated now. Then 2019 mein there was a Consumer Protection Act which was there. Before that there had actually been a Consumer Protection Act in the 80s. I think it was 1988 or something. But they enacted a new law in 2019 whereby consumer rights were further strengthened, and it acts as a supplement to contract law. There are even special courts, consumer courts, where considering how regular courts are burdened with so many cases, they have they have constituted alternate courts where you could go specifically for resolving consumer disputes. Now moving on. Now in contract formation, there are many common mistakes which are made. Now what you should avoid? Number one, ambiguous terms. This is one of the frequent mistake made. Sometimes it's not exactly a mistake. Sometimes parties do this deliberately. They insert, for instance, when it comes to prices, they don't put the exact amount. They put a range like rupees 5,000 to rupees 10,000. Now, what is the exact price that is to be paid? Nobody knows. Then when it comes to delivery, they also put date ranges, or they don't put the dates at all. Same, what happens is this contract becomes unenforceable simply because the terms were not clear. Now sure, there was a price range, but what was the exact price you had to pay? You didn't specify that, so obviously that's invalid. Then when it comes to delivery also, you didn't tell me on which date I had to deliver, or I don't even know the date. That's how. So again, either it's unenforceable, or the contract is void from the very beginning, or best case scenario it's voidable. The other party could choose to have to keep the contract, but that again is you the defaulting party. If you happen to be the defaulting party, that is, you would be at the mercy of the aggrieved party in that case. So again, it's best to be clear and exact about what it is you want. Then lack of consideration. Now, in some, there are cases where, like I said, when it comes to natural gifts, gift deeds between relatives or anything, the lack of consideration is okay. But in almost all contracts, consideration is important. So what happens is, now if consideration is not there at all, like if you agree to do something but you don't agree to accept anything, then the court will not enforce it. The court will simply ask you why you didn't agree to accept something in exchange for whatever you agreed to do. Or if you sometimes, or in case of even inadequate consideration, even though inadequate consideration is not exactly illegal or is not exactly void, court can still investigate that contract for any undue influence, thus rendering that contract potentially void or voidable. Then incapacity. Sometimes what happens is, minors, sometimes minors, especially if you are at the age of 17, you're very close to majority, they sometimes deceive. They use false identification papers, like they try to fake their birth dates and all to make it as though they were 18 or something. So they try to enter into contracts on that basis. So what happens in that case? So in that case, what happens is, you how to put this, the minor could easily claim that he was minor, and usually in case of contracts with minors, it is void ab initio. So how to prevent this? First, you need to verify from other parties as to what is the exact age of the fellow you are entering into contract with. If he looks 18 but in reality is 17 or something, you need to verify that age, verify his birth date and all. Then when it comes to unsound mind, you have to verify whether the party could actually comprehend the contract when he was signing it, or when the contract was in his hands. Sometimes it happens that in cases of minors, even if you have taken money from him, uh, yeah, or not money from, like for instance, if the minor sold you something and you paid money to him and he turned out to be a minor, even if the court deems it void, the court allows you to take the money back from that minor. Unlawful benefits are usually allowed to be taken back by the party if the contract is proven void, by the aggrieved party, that is. Then illegal object, like I said, betting contracts, or criminal contracts, or restraint of trade, apart from that goodwill selling business I told you about. Apart from that, anything is there that also renders it void. So what happens is, you have to, if you are common people, uh, ask your lawyers or whatever counsel you are using to verify the legality of the object of the contract. find out if the contract, if the object for which you're doing the contract is indeed enforceable. If the court could, if in case it went to court, could the court enforce it? You need to ascertain that for yourselves. Now, okay, before this I wanted to say sometimes excess corporate power is also there. Like for instance, a big company, this has happened way too often, especially in foreign countries and all, where big companies, they usually blackmail small companies into selling their business to them on threat of depriving them of business or just absorbing them regardless. So again, you have to ascertain that falls under undue influence, and you could the court could probably render that contract void. Or if it is excess corporate power, like say if you are in a company and some fellow over there is making you do something that you do not wish to do, and he claims that it is in his authority as the company. So what you must do is you must verify from the superiors if that fellow, if that supposed superior who made you do that, if he had the authority to make you do it, if he had the legal authority. If he didn't, then that contract is void. You could go to the court or use some other forum which that company uses and have the act nullified. A lack of free consent, like I said, coercion, undue influence, fraud. If all of that has happened, then you could render that contract, then that contract could be rendered voidable at best, or completely void if the other party chooses not to do it. So again, if such a contract is enforced, not only could the aggrieved party render it voidable, he could also enforce damages for it. Then essential elements, like I said, no price, no delivery date, nothing is specified at all. Then you need to ask the other party to include those details before finalizing the contract. Then what happens is, then next is, if you agree to sell land, this happens often in the case of poor farmers in rural areas who are often illiterate and do not have a grasp of contracts. So if they are tricked into selling their land or anything, and without proper legal documentation or contract, even contract for that matter, if their landlord simply tell them to just sell it and they would take care of everything and all, there's no written evidence at all. So what happens is, you as even if you are a poor farmer, you must or if you are a lawyer and you are in charge of these farmers and all, whoever are these poor clients, illiterate clients, you must make them aware of the need for written contracts. Oral contracts are very risky. They are valid on occasion, but most of the time it's very tricky to prove them. Most of the times it's impossible. So best to always keep a written record of everything. The In any legal case, it is usually the fact that any any evidence which you are submitting before court in a case of dispute, written evidence is usually the best evidence there is. Not to mention, it's best to obtain signatures, or if your client is illiterate, ask him to put his thumb impression. And most importantly, when you sign a contract or put an impression, retain a copy. That way, if there is any dispute or any problem that arises, you at least have something to refer to or something to submit as evidence, if nothing else. Then conditional acceptance, this also happens. It usually is the case of bargaining. You offer to sell this for this rupees, and the other party just keeps on bargaining, like trying to lower the price. Again, that's conditional, is putting conditions. As I already explained, as per this law, acceptance has to be completely unconditional. There is no such thing as uh, a conditional acceptance, that the other party is just uh, essentially, what you have to do is treat it as counter offer. If she puts a counter offer, you can accept it. if you want to, that is. You are also free to reject it. A counter offer is acceptable or rejectable at the option of the original offerer. If you accept it unconditionally, then it's a valid offer. Else not, well, good luck in finding another person to whom to make the offer. Next, again, there are practical guide in drafting enforceable contracts. Now, there is a guide I would like to say. One is when you are making an agreement, if you are a lawyer especially, if you are making an agreement, you need to first get the full legal names of the parties. Never put either first name or last name or thing. Full names. My recommendation would be for first name, middle name, last name. That's usually the full legal name. Just put it and get the addresses, full on addresses. Like right from the, if he stays in a flat, right down to the flat number, building number, the street where that building is, the area where that is, and the city where it's located, state. Hell, if you want to put, you even put the country name. Keep the details precise. Put as much detail as possible in a contract. In law, details matter a lot. Full details, it matters. Then when in if you are going to put technical details, like you are putting a sale contract, you need to, it's best to define whatever it is you are doing. Like if you are going to sell something, define the sale term. Wow, exactly what you are doing with regards to sale. Or if you are selling an object, what is the object that you are exactly selling, full description. Or the price, fully define the price. Essentially just define everything. Goes for coming as regards price, we come to consideration. Define the consideration fully, completely. Define the exact price. Define the terms, like define if you are going to buy a major expensive item and you want a down payment, define the amount of down payment. Then if you are comfortable with installments, define the installments, the amount, the term of installments, the frequency, or and even define the interest rate if the installments are not paid on time. That's what I'm saying. Then specific performance obligations. Detail the actions. Detail how if you are asking the other party to do something for you, specifically define what it is he exactly has to do. Then define under which under the time period in which he has to do. Like if you want to do him within a specific period of say 6 months, define 6 months. 6 months from this date, like 6 December or something. Then define the quality standards. Again, quality standards, it differs. Like you could say, if you are selling goods, goods have to be of this quality, or if you are performing a service, make sure it's good. Just define it properly. Conditions or this. When you are putting a contract, make sure that you have to define what are the conditions preceding the contract. Like if you are asking to do something but you want him to do something first, define that do something first properly in complete detail. Then if you are doing something or even after that you want him to do something to satisfy you further, define that as well. Although mostly conditions precedent are what is usually validated, I would advise not to put conditions subsequent. Those are a little vague, a bit murky ground. Then define how if those conditions are not satisfied, what will happen exactly. What must the the defaulting party do to satisfy the aggrieved party? That you must clearly define. Then offer and acceptance. State, then you have to clearly state what it is you are exactly offering. Then what are the terms on which you are offering this? You got to state that. Now, as I was saying, identification. Even after you make the contract, there are annexures which come after the contract. Like on annexure A, you could, if there are terms which are being repeated, but you want them to mean different things at different places, you will put an annexure for that. Or like I said, if you are putting full legal names of the parties, you have to specify what roles they are. That this party is the seller, this party is the buyer. You have to specifically enforce that. That way, there would be no confusion as to who is what, and the courts will have a clear way to resolve disputes. And when it comes to consideration, include non-monetary consideration as well. Not everybody can afford to pay money. Sometimes, if for instance, if you are buying a laptop and you are offering a very expensive watch which you had to buy at like a loan or something, and that's all you can offer, you should include something like that. Then when it comes to quality standards, usually they put annexures specifying those quality standards, though you could put that as well. Then when it comes to conditions, you could state just how those conditions are satisfied, or you could put in a grace saying that I would be willing to have those conditions viewed, as in I would be able to overlook those conditions if something bad happens to you or something. And for offer and acceptance, obviously that is very important. You have to specify that in complete detail. That is the core of the act. Then dispute resolution. Now there are various ways of dispute resolution. As I said before, litigation is there, court adjudication, as in you could go to the court, you could negotiate all of this, you could negotiate, no, not negotiate, I am sorry, let me correct myself. You could go to the court, you could ask the court, you could have the court resolve the disputes after a couple of hearings and all, but it's usually not recommendable because this course of action takes far too long. It swallows up the money of both parties, and usually the outcome is far less than satisfactory. And of course, if they are not satisfied, you could take appeals and all. But like I said, these cases go on for years. Like when I was doing my LLB, I had visited a court back in Vikhroli where there was a robbery, there was a case going on relating to theft, going on since 83, if you can imagine. That's how long it was going. Courts are pretty inefficient. I would 100% recommend to avoid courts if you can. Of course, if the parties decide to go to court, then nothing can be done. A lawyer has to accommodate his client's wishes in any way it can. And obviously, criminal cases there is no alternate. But my personal recommendation, avoid courts if you can. Now there are other ways as well. The Arbitration and Conciliation Act 1996 also specifies this. Number one, negotiation. Negotiation is when two parties are present at a specific place, or through online forums, video conferencing or whatever it is, you talk amongst yourselves. You constantly bargain. You constantly try to settle. Constantly try to settle agreements. You constantly try to settle terms among you basically try to come to agreeable terms. I'm sorry if I'm getting a bit long-winded here, my explanation is a bit like that, excuse me. Just to put it shortly, both the parties, they try to come to terms favorable to both of them, to each other, to say to put it this way. So this is pretty much informal, confidential. Essentially, there is no specific written record of negotiations. This happens at a specific setting. Both the parties, they either do video conferencing or they meet up at a specific place. They constantly argue, they talk amongst each other, they try to settle terms, and yeah, and they come and the contract is finalized in terms favorable to both of them. Now the timeline for this is usually either days or weeks. Yeah, it takes a long time. It depends. If, for instance, if it is a very small firm or very small contract, it just takes a couple of hours. But if it is like large companies, mergers, acquisitions or something, it could take months, sometimes even more than that. It depends on the size of parties. It's subjective. Then next we come to arbitration. Arbitration is somewhat more formal. It's a bit related to litigation. It's just that sometimes it happens in cases, and I have experienced this personally uh, in family law courts, where this judge, she was hearing a case, and she got tired of the constant arguing that was going on. And as you know, judges themselves get too many cases per hearing. They are overburdened, far too much. So they usually, how to put this, they usually assign a specific arbitrator to whom they ask the parties to assign the case to for quick resolution. So what happens is the arbitrator decides it in a more informal setting. It's still a lot more formal than negotiation or mediation, but it's still relatively informal, at least compared to litigation. So they assign it, and how to put this, as the arbitrator, he hears all the arguments, and then he drafts an award where he agrees to submit, where he not submit, sorry, where he decides the case in favor of either one party or the other. Usually the arbitration award is completely binding, and an appeal from such award is not encouraged. But it is possible in certain cases to take the case back to the court if you are not satisfied with the arbitration award, but it's usually not recommendable. Mediation. Mediation means this is a lot more informal than arbitration. It's usually, this usually more applies more to family disputes or property disputes or anything, usually within family. So what happens is, if the family takes the case to court, the court oftentimes appoints a mediator for this. So what happens is, the mediator, he appoints uh, the mediator is, he usually assists the parties in coming to a settlement, a voluntary settlement, mind you, a one on which both parties agree on. The mediator, in mediation, it is not compulsory to abide by the settlement. It is only if both the parties agree amongst each other that the settlement is perfectly fine, that is more preferable to either litigation or arbitration, then they agree to it. Now, what is the timeline here? Again, it depends on the subject matter in dispute. The subject matter in dispute is minor, a couple of days, maybe, or weeks. Sometimes if it is major, like huge, like property involving crores of rupees or anything, it could take as long as months or even years. Escalate. Now what is the trick here? Usually in commercial contracts, those of you who had experience of it would have seen that at the end of each commercial contract, they usually put an arbitration clause. They specify very clearly that this, in the event of a dispute, this contract will be submitted to arbitration at this place, at this jurisdiction, and the arbitration award will be final. Now it is not actually final, you could take it to court, but they usually put it this way so that the court, it does not get any further, so that neither of the parties' time or money is unnecessarily wasted. So it's important to put that clause. Our mediation and negotiation is pretty much implied, so no clause there. Mediation also, it's pretty voluntary. Now, evidence and burden. Again, if the contract terms, they are usually primary. Whenever a case goes to court, the contract terms are the ones which are argued upon. Their exactness, their exactly how vague they are, how exact they are, under what circumstances are they applicable or not applicable, and so on. Sometimes you even call in witness, like if there are people involved in the implementation of the contract, or even in the going as far as the formulation and drafting process, you call them and get them to testify regarding what exactly happened. Obviously, it's a bit of a messy process, and one, like I said, this happens during litigation, and it is recommendable not to take it that far, but in case it goes this far, it's best to do all this. Now, when it, if they, this is in criminal cases. In civil cases also there are witnesses, but it mostly relies on the balance of probabilities. As in, to put it simply, what was more likely to happen in a given situation, this or this? So they weigh the probabilities, and if they decide on a mathematical randomality situation that this was what was more likely to happen, and this, the court decides on the basis of this and puts the settlement. Now, as you can see in the slide, there is a decision tree where it takes. Now, I would not say that this is exactly how it is. Those of you who are working professionals and all would know that even negotiation and mediation often take a very long time, especially the matter is very big. So, but it is definitely shorter than the litigation, so it's still recommendable. But those of you who are beginners, please keep in mind that this is not the exact terms. This is just a rough estimation of how much time it would normally take for either of these dispute resolution methods to resolve. It is not exact, it is not perfect. Everything is subjective. That's how the law is usually is. That is what you keep in mind. Whenever an act specifies provisions, it is meant to be applied as strictly as you can on the basis of the circumstances in which you are involved. And should a dispute happen, the court will always use a subjective interpretation. An objective of even in cases of supposedly rock solid provisions, they would try to somewhat alter its applicability on the basis of what was how to put it, on the basis of what exactly suited the circumstance better. So basically it is this provision, the provision and the surrounding circumstance of the case. You need to take both of them into account and then formulate the contract appropriately. Well, you can all look at these key takeaways. I'm afraid I won't be specifying this, but just to put it briefly, offer, acceptance, consideration. These three are absolutely vital for a contract. Free consent is mandatory. Non consent taken by coercion, undue influence, fraud, misrepresentation, they are not usually enforced. Even if they are, it's at the mercy of the aggrieved party. So don't go ahead and do this. Capacity is 18 plus and sound mind 18 minus also, but that's up to the guardians of that fellow, below 18 fellow. Then object has to be lawful, it has to abide by public policy. Then performance obligations, they have to be binding. Then they are binding, they have to be binding. Then breach leads to remedies. So essentially, if you breach a contract, if someone breaches a contract and you are aggrieved party, you can always seek remedies in any way, like I've explained below. Then communication of offer acceptance has to be very clear, very vocal, better to make it written. In law, written documentation is always the best form of proof. Oral is never suitable. I would recommend never to make oral acceptance, oral contracts in any way. In some cases they could be enforceable, but it is very difficult to prove them. That is why always opt for written form. Always. Then for if you are making very complex contracts and you can't really understand the terms involved, always seek advice of an experienced lawyer or your family if suppose if you are in a long established family, you are using a family lawyer, seek the consent of that family lawyer, whatever. Well, now this is the conclusion. The Indian Contract Act, as we all know, it is one of the basic foundations of Indian law, especially of the business world, of trade. Pretty much everything we do is almost pretty much governed by this act. So this act, despite it being formulated in the British era, it has endured until now. Of course, I would rather after independence we scrap the British laws and put Indian laws, but it would have been too much work. So anyway, that's not for lack of fact. We have modified the British laws to the best extent possible to suit independent Indian context as much as possible. So I guess fellows, that much is it, and thank you all for watching my video. Please subscribe to my new YouTube channel here, and I'll be putting forth more videos in as best a way as I can, trying to offer you more legal as well as history being my favorite subjects. I would impart historical knowledge to you too. So thank you all. Have an excellent day. Bye bye. Thank you all for watching.